good morning, good afternoon, or good evening, dear audience, depending on wherever in the world you may be. It's my utmost pleasure and privilege to formally once again invite Professor Jeffrey Dunoff for his today's talk. We are very lucky to go through, at least I have been very lucky to go through his draft, which he has very generously shared a paper, which is going to be published in the American Journal of International Law. Now, before I formally invite Professor Dunoff to deliver his speech, let me say a few words about our topic this evening. Judicial dissent, as a student of law, it has always intrigued me that judges know that this decision is not going to have at least any immediate practical impact on the case at hand, but they would, despite that, they would spend their time, they would spend their effort, energy on it, and how do they make those choices? How do they make those decisions? And perhaps this is even more intriguing in international law. The draft that I was really privileged to read, it's a very comprehensive one. It takes several questions that I do not think I have read anywhere else in addressing those questions or addressing them in the way that Professor Dunoff and his co-author has done. Principally, he has taken three major international courts: the International Court of Justice, the European Court of Justice, and the European Court of Human Rights. And he has posed some questions that how the judicial dissent is impacting the development of international law. To what extent this may or may not have an impact on the judicial independence, and also the question of legitimacy of the court where this dissent is in practice. And I think he has very successfully shown that the defenders of dissent, as well as those who have their question marks about dissent, both of them are in some ways perhaps sold their arguments. And in some cases, it's not just about dissent, but it's more about other factors than dissent that may have had impact on not only that verdict, but also the dissenting opinion or separate opinion coupled with other things. And I look forward to his full presentation, and of course, all the questions that dear audience you may pose. So over to you, Professor Dunoff, for your presentation. Thank you all.
Well, thank you. Thank you so much for the kind introduction, and more so, thank you for the invitation to speak with you today. It really is an honor for me to be part of the NSU law webinar series, particularly because I've actually had the privilege of attending a number of the previous talks in the series. And I don't think that I can hope to match the brilliance and erudition of the talks that I had the pleasure of attending. But I am grateful for the opportunity to make at least a small contribution to the vibrant intellectual community that Professor Islam, along with his colleagues at the law school, have created. Hopefully before too long, it'll be possible to have meetings like this in person. But in the meantime, I'm very happy to have the opportunity to contribute to your efforts to build bridges among international lawyers and scholars and students from around the globe. And I'm grateful to all of you for taking time out of your busy schedules to be here. And I've been looking forward to this conversation. So what I'll do today or tonight is I'll present part of a larger project that I'm working on with Mark Pollack, a political scientist at my university at Temple. And working with a social scientist, I've learned that the convention is to begin by saying that the paper is motivated by a puzzle. So here's ours. International courts, or ICs, come in various forms, but they all broadly engage in the same enterprise. They find facts, they interpret law, and they determine if a legal right has been violated, and then they announce their decisions through a judicial opinion. So why is it that some courts routinely issue judgments accompanied by one or more concurrences or dissents, which we'll collectively call dissent? And why do some courts never issue dissents and other courts are somewhere in the middle? And what are the implications of these different practices? How do they impact, in particular, judicial independence, legitimacy, and the development of legal doctrine? Now, if you're not a social scientist and explaining variation is not what you're trained to do, here's another way to understand this project. As Professor Islam suggested, judicial dissent, they're paradoxical texts. Unlike in Homeric times, when judges who issued the most correct decision received pieces of gold, modern jurists lack any obvious incentive to issue dissents. They have no formal legal effect. And yet, as Professor Islam said, judges spend considerable time and energy trying to draft and craft these opinions. So why do they do that? Why do they do that? In addition, these opinions are the focus of intense scholarly focus. So just the past few years, we've seen important papers on dissent in international criminal courts, their impact on ICJ authority, and their use as evidence of backsliding by human rights courts. So this research very helpfully highlights the importance, the centrality of dissent at many ICs, but these writings look at a specific court or a specific legal regime, or sometimes at a specific jurists. And the lack of a comparative analysis leaves us with little understanding of when or why judges issue dissents. Moreover, these writings have a curious gap. They generally sidestep three central questions raised by dissent: their impact on legitimacy, on judicial independence, and the development of legal doctrine. And that omission is even more striking because there's a long history of debate over dissent at international courts, and those debates focus particularly on these three issues. So this paper tries to fill that gap. If you think about a dissent, really it is a road not taken. It sets out distinctions or approaches that diverge from the majorities. And the dissent's influence depends on its ability to set out a more attractive vision of what the law could be. So the dissent invites the reader to compare. Which approaches does the reader find more appealing, more attractive? Well, for a paper on dissent, our approach is likewise comparative. We're going to pursue a scholarly road not taken and compare dissent practices across different courts. It's really the first study I'm aware of that does this comparative analysis. We have three main goals. One is broadly historical. We want to recover. We want to excavate a rich history of contestation over dissent. We want to illuminate the key claims in those earlier debates. But the second and more important goal is forward-looking. We want to advance those debates by examining the impact of dissent, and we do so through multiple methods. We interviewed current and former judges at ICs. We read the scholarship and other secondary literature. And then finally, we use these dissent practices to shed light upon larger issues, including the design and function of ICs, the determinants of judicial behavior, and the methodologies appropriate to the study of courts. I won't try to summarize all of this today. Instead, my talk will focus on three central parts. First, I'll review these sharply conflicting claims about dissent's impact. Second, to make sense of these claims, I'll turn from theory to practice. I'll look at dissent practices at several courts. And then finally, drawing on the case studies, I'll return to the three key debates and to preview our conclusions. The central claims in each of the debates is mistaken, and they're each mistaken in a different way. Okay, so since the Hague Peace Conferences that created the PCA to current proposals for a new multilateral investment court, there's been substantial debate over dissent. And I'm going to foreground three of the most important debates. The first, do dissents threaten or enhance judicial independence? Given concerns over national bias and the structural reality that judges are elected by the states that appear before them, questions of independence at ICs are highly salient. So some claim that unitary judgments preserve judicial independence. Why? Because the states at election time and re-election time don't know a judge's position, so they can't retaliate. Others say that separate opinions let judges explain their reasoning that led them to a particular result, that they can preempt charges of political influence or bias. And in this view, dissents enhance independence. A second debate focuses on legitimacy. So some claim courts are most legitimate when they speak with one institutional voice, not multiple voices of individual judges. So US Judge Learned Hand wrote that dissent cancels the impact of monolithic solidarity upon which court's authority largely depends. And Edvard Hambro, the ICJ's first registrar, echoed this claim. He wrote that dissents undermine a judgment's authority, which will carry less weight, be less respected. So the claim here is dissents undermine legitimacy. But others say dissents enhance legitimacy. First, they tell losing parties the court took their views seriously. Moreover, dissents signal something important, distinctive about judicial reasoning. When sitting as a judge ad hoc, Tom Frank wrote that dissents attest to the richness of the court's collegial deliberative process, which enhances the court's legitimacy. A third debate concerns dissent's impact on doctrine. The issue is critical given international courts' contribution to law development. So this contribution is a function of a judgment's content and the strength of its reasoning. Dissent's defenders say that dissents sharpen and improve majority opinions and hence enhance IC's role in law development. But on the other hand, critics say that fractured decisions with multiple opinions undermine legal certainty, create confusion for parties and future courts. So I'll assess these claims in a few minutes, but for now, let me offer a few comments on the structure of these debates. First, the various claims and counterclaims are highly stable. That is, virtually the same debates using virtually the same terms are heard 100 years ago at the Hague Conference and in today's debates over proposed investment court. So the debates are stable across time. They're also stable across location, by which I mean virtually identical claims in virtually identical language are made in debates at domestic courts and at international courts. Despite considerable differences in institutional structure and institutional environment, these debates largely mirror each other. So I'll give just one quick illustration. Who said a dissent is an appeal to the brooding spirit of the law when a later day decision may correct the court's current error? Well, you might have guessed Charles Evans Hughes, a Chief Justice of the US Supreme Court, and you'd be right. Or you might have guessed ICJ Judge Stephen Schwabel, who used this exact quote in his Nicaragua dissent. Or you might have guessed ICJ Judge Philip Jessup, who used this same language in his dissent in Southwest Africa. But if you thought this was just another one of those crazy American ideas about law, you'd be wrong, because the exact same phrase was used by ICJ judges Hirsch Lauderpacht and Shuhabuddin in their extrajudicial writings. I'll suggest in a few minutes that this oft-repeated claim is probably incorrect. But for now, the key point is that parallel, if not identical, arguments are made on the international and domestic plane, notwithstanding the important structural differences. Finally, the claims in the dissent debates are largely conclusory. Little or no evidence is offered to support the claims. But here's the thing. In recent years, international courts have proliferated. They've issued over 30,000 judgments. Debates over dissent's impact no longer need to rest on abstract normative claims or a priori propositions. We can add some empirics to the discussion, and that's one important goal of our project. Second, the debates tend to focus on a single court like the ICJ. We want to look across courts And I'm going to highlight in particular the ICJ, the European Court of Justice, and the European Court of Human Rights. And then I'll ask whether our findings might travel to the broader universe of courts. Okay, so what do we find? Well, we start by looking at a factor that the domestic debate largely ignores, and that is debates over court statutes and drafting histories. And several findings emerge. One is that debates over dissent were often prominent. At the PCIJ, the debate pitted Léon Bourgeois and Lord Balfour, who wanted a rule permitting dissents, and they were opposed by the Dutch delegate Bernhard Loder, who was opposed. The PCIJ statute does authorize dissent, with only the Netherlands voting in opposition. If we move to negotiations over the first European court, all the member states were civil law jurisdictions. None had a domestic tradition of dissent, but still the debate came up. Once again, the Dutch found themselves isolated, but in sharp contrast to the PCIJ, where they were the only ones opposed to dissent, here the Dutch were the most receptive to dissent. All the others were opposed. Why were they opposed? Maurice Lagrange reports that dissent was considered, from the public perception at least, a threat to independence. And the counter-argument was that dissents should be permitted so that legal doctrine could be developed. So if we step back from the particulars of these and other negotiations, three findings emerge. First, dissent was often frequent, prominent in the debates. The negotiators clearly foresaw the debates over independence, over legitimacy, over law development that would later preoccupy judges and scholars. Second, out of all these various debates, two basic models emerged. One is permissive, a statute that explicitly permits but does not require judges to dissent. And the second model is statutes that are silent on dissent. We see this at the ECJ, the EFTA court, the Andean court, other regional economic integration courts. So across time, across subject area, across courts, we see two basic models with much imitation, much mimesis as later courts get formed. Third, the statutes that permit but don't require dissent provide judges little guidance. They're consistent with a wide range of dissent practices. So because the rules are underdetermining, we turn to judicial practice. Given open-ended statutes, how do judges in fact act? And the answer is we see wide variation across courts, wide variation in judicial behavior. Substantial material variation, the number of dissents, substantial ideational variation. What do judges understand by engaging in dissent? We might even say we see different cultures of dissent. I'll start with the material practice. It spans a continuum. At one end, dissent has always been common at the PCIJ and ICJ. Across 7 decades of ICJ practice, every single advisory opinion and every single judgment in contentious cases, with one exception, they've all been accompanied by separate opinions. More specifically, the empirics show an average of more than 4 separate opinions in the ICJ's first 243 decisions. At the other end of the continuum is the ECJ. Thousands of judgments, but not a single dissent. This doesn't mean every judge agreed on every single point, just that there's no public record of disagreement. Other courts lie in between these poles. In the ECHR's first 4 decades, the court issued over 2,000 judgments. Of these, some 602, or 1/3, had one or more separate opinions. And in recent years, some 70% of grand chamber opinions have had separate opinions. Dissent is also common at international criminal tribunals. A recent study shows nearly 3/4 of appellate judgments have dissents. But in contrast, dissent is less common in international economic law. So in investment arbitrations, we find dissents in roughly 20% of published awards, and dissent is very rare at the trade system. During GATT years, only 3 of 143 panel reports had dissents. That's roughly 2%. During the appellate body's first decade, not a single dissent. And since then, really only a handful of separate opinions have been issued. So what could explain this dramatic variation? Well, explaining behavior is tricky. Different judges clearly have different motivations. So at the risk of oversimplification, I'll try to summarize our sense of the inner subjective understandings of the judges at different courts. So first, the ICJ. George Abisab once noted that the term world court is peculiar to English. So what could this phrase mean? He said for the ICJ to truly be a world court, it would have to be universalist in composition, outlook, and vocation. So how could a court embody or demonstrate this universalism? Well, one way would be to have all judges participate fully in the drafting process, and another would be for the court to speak with many voices, for the court's written work product to be as multivocal as the world it purports to represent. ECJ judges, they approach it differently. They're concerned with judicial independence, and that leads them to a practice of no dissent. Here's the logic. They serve for 6-year renewable terms. If a state doesn't know a judge's position, it cannot retaliate against him or her at re-election time. So they say unanimity protects their independence. The other thing they told us is that unanimity, enhances the court's authority and legitimacy. When we speak to ECHR judges, they have a different idea. They think dissent enhances legitimacy. Why? For them, dissent increases transparency. It improves their jurisprudence. It strengthens their legitimacy. At the WTO, well, appellate body members say they decided to speak with one voice to build the legitimacy of the then brand new system. The idea the new court is at its strongest, its most authoritative when it's unanimous. So we see a strikingly wide range of material and ideational practices across these courts. Okay, well, with this rich empirical record before us, with these diverse practices in mind, let's return to the debates over the impact of dissent. First, do dissents enhance or threaten independence? We think this framing misleadingly directs attention to 2 features of courts, but we think the underlying dynamic actually involves 3. The third feature is whether judicial terms are renewable. So consider the European Court of Human Rights. Its judges are independent. It has high dissent rates. Originally, these judges had renewable 9-year terms. But by the late 1990s, states were punishing judges for unwelcome decisions by not reappointing them. This led to concerns that writing separately threatened independence, and it led to a shift to non-renewable 9-year terms. The explicit rationale was to protect judicial independence. So today we see high dissent rates at this court, but that's a function of having non-renewable terms. At the ECJ and the WTO, in contrast, terms are renewable, and these judges see dissents as threatening independence. In short, the conventional debates misleadingly highlight a relationship between 2 features. We think we should be looking at a relationship among 3. There's 3 relevant factors. You can maximize 2 of them, but no more than 2 at any one time. And elsewhere, we've called this complex set of trade-offs the judicial trilemma. So studying dissent helps us see that there are trade-offs among different design features at a court. All right, what about dissents and legitimacy? That's a hard question, methodologically hard, because levels of legitimacy are not directly observable, they're not directly measurable. And even if we had data that judgments with dissent had lower levels of legitimacy, we'd still have a causation problem, because it's possible, maybe likely, that the quality or content of majority decision prompts both dissents and challenges to legitimacy. So what on first glance might seem to be the impact of dissent on legitimacy might in fact be the impact of the majority opinion on both. So given these methodological challenges, we pursue a most likely cases strategy. That is, we look for cases where we're most likely to see delegitimating impact of dissent. So we looked for cases that were politically salient, that featured strong dissents, and that triggered legitimacy critiques. If the presence of dissent undermines legitimacy, these are the cases where we'd see it. But if the legitimacy debates here didn't focus on dissent, then we might conclude dissent is not what drives perception of legitimacy. So, for example, let's consider the court's most controversial opinion, the second judgment in Southwest Africa. There were very strong critiques. The paper talks about 3 by Rosalind Higgins, by Michael Reisman, by Richard Falk. They're all highly critical. They each present very different arguments, but none focuses on the fact of dissent. None bases their argument on the fact the court was deeply divided. Indeed, Higgins expressly rejects this line of argument. She says it's not fair to criticize or disparage opinions by stressing the size of the majority. So in these leading and quite powerful and thorough critiques by leading scholars, they focus on the court's legal analysis. And at least one of them explicitly rejects criticizing the judgment on the ground that it prompted a large number of dissents. We also look at a few of the more recent cases that have generated large numbers of dissents, like the nuclear weapons case, where every judge wrote, and the Marshall Islands case. And we see a similar story here. To the extent these decisions spark critiques, legitimacy critiques, they're really about the merits of the judgment. They're not about the fact of dissent. And so our tentative thinking is it's not the presence of dissent, but rather patterns of dissent that raise legitimacy concerns. If judges from, say, the global north were consistently on one side and judges from the global south consistently on the other, or a similar pattern emerged, that would be problematic. That would signal that politics, not law, was in play. When the voting patterns suggest that the judges are politicians in robes, that's what threatens legitimacy. So the Marshall Islands case is a good example. It did not escape notice that all the judges from nuclear weapon states voted to dismiss those actions. Finally, our findings suggest that courts with different dissent practices can broadly be considered legitimate. So the 2 European courts historically enjoy high patterns and levels of social legitimacy, but they have diametrically opposed dissent practices. So we think there's multiple paths to legitimacy, and the simple dichotomous framing between dissent and legitimacy really masks and obscures a substantially more complex relationship. Finally, dissent and law development. Here, we think the debate fails to sufficiently distinguish between 2 different ways that dissent can contribute to doctrine. One is by sharpening the majority's arguments and rationale. That almost certainly occurs. The second is that the dissent is an appeal to the future brooding spirit of the law, persuades the future court to change direction, as all these judges suggest. We think, in fact, empirically, this rarely occurs. And even when the court reverses course, it's not clear that a dissent from years earlier is what caused the change in the court's direction. Okay, I know what you're thinking. You're thinking, okay, this analysis has a big problem. To state the obvious, these studies lack geographic diversity. The courts I've discussed were all established in Europe after World War II to include only European states in their founding treaties, and particularly at a time when we problematize international law's European origins, why foreground these courts? Now, as a matter of research design, the decision to include the ICJ was not hard. It's the oldest of the courts. It's the only court of general jurisdiction and universal membership. It's the UN's principal judicial organ. It is often called the apex court, often cited by other international courts. It's the first among equals. It occupies a large space in the international legal imaginary. And ICJ judges are prolific dissenters. So it's really a good case study of the effects of frequent dissent. Okay, well, having chosen a universal court, we wanted to analyze two other courts, regional courts with diverse dissent practices, but which are otherwise similar in terms of region and membership. The two European courts have opposing dissent practices, so we have variation on the key variable, but we can control for other contextual factors. They have similar membership, formed at roughly the same time. Each has issued tens of thousands of judgments. Each has developed the law boldly. Each has significantly impacted European law and politics. In research design terms, these two courts represent a most similar systems design. Other courts, of course, would be geographically more representative, but we'd have questions whether any variation might reflect geographical differences rather than the effect of dissent. The two European courts are useful for another reason. They're the first generation of regional courts, and they've really served as models for later economic and human rights courts in other regions. We think of them as index cases. They're the first instance of a regional court. So if we compare a European court with a court from another region, we would violate the research design principle of case independence. So to be clear, these arguments only suggest that the European courts are a good place to start, but they're only the beginning of a truly comparative exercise. So we see a long road ahead in terms of looking at other courts, a much larger universe of courts. The paper very briefly looks at 24 operational courts. Very quickly, we do not see systematic variation by geographic region. So courts in Asia and in Africa, like in Europe, sometimes permit dissent and have high rates of dissent, sometimes don't, have low dissent rates. There's no clear geographic variation. There is, however, interesting patterns when we look at the functional subject areas. We divide the courts into 5 constellations. The first constellation is global courts, the PCIJ, its successor, the ICJ, ITLOS, which largely follows the ICJ in this. These are all high dissent courts. Secondly, there's regional human rights courts. The statutes are modeled on their European predecessor, but we see some interesting wrinkles. So for example, in most courts, dissent practices are very stable, very sticky, but the European court shows, the African court shows an interesting shift. Dissent was quite common in the African court's early years, but more recently, dissent is highly infrequent. Why is this? We don't know. This is an intriguing topic for future research. A third constellation is international criminal courts. Here, dissent is quite common, although a recent study suggests it has little impact on law development. One other thought about dissent in this domain, one function of international criminal courts is to create an authoritative historical account. Several scholars have identified a subset of dissents that seek to challenge those historical narratives. The classic case, of course, is Judge Powell's dissent at the Tokyo Tribunal. And so this sort of reminds us that the impact of dissent can be a function of the specific role of trials in particular regimes. A fourth category here is trade courts, the WTO, where dissent is rare. I've mentioned both structural and ideational reasons for this. The AB is not functioning now, so this debate is dormant. But if a new appellate mechanism comes into being, I think we can predict that this argument over dissents, will revive. There's a fifth group of courts, regional or economic integration courts. Here we find often statutory silence or explicit prohibition on dissent. This slide is hard to read, for which I apologize, but that's kind of the point. The point is there are many of these courts, and the twist here is even when the courts adopt the ECJ model and much ECJ jurisprudence, they sometimes diverge when it comes to dissent. So for example, the Central American Court of Justice, the statute does not authorize dissent, and yet there are cases where judges have issued dissent, notwithstanding a lack of statutory authority. Similarly, the statute creating Mercosur's Permanent Review Court does not authorize dissent. We have seen cases with dissents. The Andean Tribunal of Justice does not authorize dissent, yet its judges seriously debated whether to change their historic practice of unanimous decisions. They ultimately decided not to pursue this path, but it's a research project for future years to figure out what was driving these courts in these very interesting and particular decisions. Okay, where does all this leave us? For over a century, debates over dissent's impacts have been virtually unchanged. Our contribution is to say the received wisdom here, it's overly simplistic, it's misleading. We try to provide a more nuanced account. First, we don't see a one-to-one relationship between dissent and independence. We think it's mediated by a third factor, terms of office. So if we want to understand judicial independence, we need a clear understanding of interactions among three factors. Second, we don't see evidence that dissent undermines legitimacy. We think dissent is consistent with legitimacy, provided that patterns of dissent don't reveal a politicized bench. Third, dissents do serve the clarity and development of law, but not in the way dissent's defenders think. So let me close very quickly with three thoughts. First, the current inattention to dissent has a cost. Form follows function. In law as elsewhere, the failure to study the shape of court judgments leaves unexplored a fruitful way of understanding the functions and efficacy of international courts. Second, we break with dominant approaches by treating international courts as a they, not an it. Most ICs, decision-making, it's a group process, but we typically treat courts as a monolithic entity, and few studies take account of the collective nature of the process. Finally, this is just a first step in a comparative study across a larger universe of international courts. This is just, an invitation, really. It's an invitation for others to join us in this study. Why might you do that? Precisely because today, international courts are under stress. Several years ago, we could confidently talk about the judicialization of international relations. Today, those courts are under challenge, and their ability to maintain authority within larger systems of global governance is at risk. If we want to maintain judicial independence, maintain international court legitimacy, help them develop international law, we better understand the role of dissent, and we better move beyond the stale and inconclusive debates if we want to help preserve the role of courts going forward. Thanks for your attention. Eager to hear your questions and criticisms.
Thank you very much, Professor Dunoff. If I may put to you the first question, which is on the identity of the judges or the judicial tradition from which they are coming from. So is there any difference in terms of the pattern, depending on whether the judge is from the common law legal system or civil law legal system? Do you notice any such pattern in the judgments that you have studied?
What a great question. I'm going to try to share my screen again just for a moment, because we began the paper with precisely that hypothesis. Could there be a difference between civil law judges coming from traditions that typically do not have, sometimes do not permit dissent, as opposed to common law judges? We call this the legal traditions hypothesis. Up on screen is, I have a number of these slides. I'll just show one from the PCIJ. And we looked. We did the empirics on precisely that question. And interestingly, what we found is no systematic variation between dissent rates, surprisingly, to us at least, surprisingly, no systematic variation. Sort of the top 2/3 of this slide is judges from civil law systems where dissent rates range from 0, up to 40% of cases. Bottom of the page is common law tradition, ranges from 0 to 50%. So we didn't see that systematic variation. Why? One thought is that the judges who get elected, elected to the international courts, tend in general to be very, very familiar with that court, very familiar with that court's practice. And so even if it's different from their national tradition, to the extent they've been socialized into whatever the particular court is, they tend to take very easily to the tradition at their particular courts. But that was a really important question for us to investigate. And at least to us, the finding was a little bit surprising.
Thank you for that answer. A question from one of our teaching assistants, Cyrene Azabi Saim. She has asked, how much do the dissenting judgments expressed in local newspapers or media outlets impact the legality or legitimacy of the dissent? I think in your paper, you also have demonstrated some media reports dwelling on this issue. So your thoughts on that, please.
So thank you. So this is another great question. I'm tempted to say great minds think alike because we had exactly this question, just like the previous one. And so in the paper, not in the talk, but in the paper, we did precisely what the intuition behind your question invites us to do. Pardon me. We took, excuse me, we looked at some of the most controversial cases, more recent ones from ECJ and ECHR, and we did a search, a systematic search of media discussions of those controversial cases, cases like SAS, cases like Hearst. And again, much to our surprise, the leading media accounts, the leading press releases, the leading politicians, the leading editorials, even when they were very critical, they did not tend to focus on the dissents. Similarly, we looked at the scholarship on those cases. I mentioned just in the ICJ context, we also did it for the 2 European courts. Once again, it's a little more nuanced, but by and large, it's fair to say that for people who criticized a court or a judgment on legitimacy grounds, by and large, the argument was not, oh, look, the court itself was fractured. Oh, look, the court itself was split. Oh, look, you couldn't even persuade your colleagues. Doesn't this show the illegitimacy? People did not make that move. And it's all the more remarkable that they did not make that move because there was a decades and sometimes century-long tradition of having made that move. So we think that silence here actually speaks volumes.
Thank you. Thank you for that answer. The next question would be on what about the judge's experience after dissent? You have somehow alluded to this, that in some cases there's a perception that maybe taking a position or a dissenting position being revealed can have an impact on the career of the judge. And I think in your paper, you have mentioned Professor Anthony Angi, perhaps raising that point that maybe one of the great dissenters, Jaswera Muntri, his re-election bid was unsuccessful, mainly because he took very much strong dissenting positions in certain cases. So what about the judges? Maybe you cannot quote them, but do the judges really share this concern, or is there any public record on any of the judges commenting on how their judicial position may have influenced their career or re-election bid? Anything on that, please?
Yeah, so this is another really important question. You know, how can we right? So the hypothesis is that states might retaliate. And the question, one way to hear it is, well, what's the evidence? You know, that's plausible, but what's the evidence? And that's really hard to answer because, to focus on the ICJ for a moment, there's probably any number of reasons that motivate a state to vote for or against a particular candidate. Maybe it has to do with the quality of the candidate, plausible. Maybe it has to do with a judgment or a separate opinion, that's plausible. Maybe it's part of some trade of votes. I'll vote for your person in issue A, but you give me your vote on separate issue B. It might have nothing at all to do with the particular individual at issue. And there is lots in the literature to suggest this sort of vote trading happens all the time. So, right, what's the evidence that judges need to worry against being retaliated? And here, conceitedly, it is anecdotal at best, right? So Percy Spender, who cast the president judge who cast the tie-breaking vote in Southwest Africa, came under very, very severe criticism. he decided not to run again. There could be lots of reasons. One informed speculation is, well, he knew he couldn't possibly win. So that would be an example. In fact, the Australian who was nominated in his place, Kenneth Bailey, who was very well qualified, didn't get elected, probably as part of the adverse reaction to Spender's vote. Tony Angie, in a very interesting piece about Judge Weeramanchi, suggests that, as Professor Islam suggests that this might have been the reason, but it's very hard to know. The ECJ is a little bit the case of the dog that didn't bark, because there aren't dissents. We would never see that evidence. But I think there are two other cases where maybe that evidence is stronger. The first is the WTO appellate body. And here, the appellate body panel on any case is only 3 members. If there's a dissent by rule, by statute, they have to be anonymous. But since there's only 3 members, WTO, Geneva insiders, they think they can identify who was the dissenter. Maybe they're right, maybe they're wrong, but they think they can. There were some cases that the US lost on zeroing, a very technical issue of international trade law. And thereafter, in 2 of these instances, 2 US judges who did not dissent from cases where the US lost, they did not dissent, they went with the majority, the US did not renominate them. So arguably, this is a case where a state could identify a judge's position on a particular issue of great importance to that state, and they decided to retaliate against that judge. Similarly, in the ECHR, originally, there were renewable terms, and Eric Voten sort of has the leading paper on this, and he goes through the details of a handful of judges, often from East Europe, judges who issued individual opinions that their nominating state found uncongenial, and those judges were not nominated. But the question's a good one, because the argument here is inferential in part. There's very little direct evidence.
Thank you for that answer. The next question that we have is on, let's say you take another paper, you take another project on the road not taken part 2. So what would be your research questions that perhaps you could not do within the confines of this article that is going to be published in the AZL? So if maybe not you, maybe if one of the participants this evening, if he or she would have liked to do a paper, what are the questions that you think are there for them to be explored on this rich scholarly debate?
So I love that question, in part because I hope that the students listening here read this paper or hear this talk as an invitation, like a personal invitation for you to join me on this road, right? Because there's a big universe of courts, and any of us, right? No one person is going to be an expert on 24 international courts. None of us. My colleague happens to have great expertise on the European courts. I know a little bit about the WTO and the ICJ, but no one person. So this really does need to be a collaborative project. The courts I did not discuss very much today are courts where I am, I should know more, but I just don't. And so hopefully this paper can be a little bit of an inspiration in 2 ways. One is a little bit on domains of inquiry. So to the extent judicial independence or court legitimacy or development of doctrine, right? The issues, the substantive issues, the normative issues that we focus on are contentious and contested at these other courts. The paper maybe can be a little bit of a model to be improved on, to be sure, but a model in terms of questions to ask, areas to explore. Maybe more importantly, it could be a little bit of a model in terms of methodology. So this is really a domain where any number of scholarly methodologies could be useful. They could be ethnographic interviews with judges or former judges or secretariat officials or practitioners. It could be much more quantitative. You could do time series analysis of dissent rates over time. It could be more doctrinal. Are dissents more influential in, let us say, procedural areas, maybe because they tend to recur, than in substantive areas, where maybe because of a light caseload, issues don't tend to recur, right? There would be any number of different methodologies. And so the sort of happy news in response to that question is, this is a wide open field, because no one really before us, has really engaged in this comparative exercise. If you want to do this, you can chart the path. You can chart the path, right? There is, the field is wide open. And so if any of these methodological approaches are attractive to you, if any of these substantive questions are attractive to you, the field is yours. You could be the leading scholar in that domain.
Thank you for that answer, and maybe clues for many of our participants who are students interested in this area. Now, another question that we have is on the sort of difference that maybe international court should take, or perhaps may have taken from, let's say, the domestic practice in the US or many other leading jurisdictions, that in terms of the dissent, do you see any real difference in the approach of the judges, or any sort of theoretical reason for them to take a different approach? So two aspects of it, maybe. One is what they have done, and maybe what they should do.
Yeah, great. So maybe I'll take the second half first and then circle back. In terms of sort of the theory, maybe, why should we expect it to be similar practice? Why should we expect it to be different? I've suggested the debates tend to mirror each other, but there are reasons to think theoretically that maybe there should be some differences. I'll just mention a few. So for example, in the US context, where debate over dissent is very highly developed, but in the US context, of course, federal judges here, a little bit unusual, federal judges in the United States enjoy life tenure. That's a little bit unusual across domestic courts. It is unheard of at international courts. And if we're right that the prospect of judicial reelection is important, or at least perceived to be important, that's a really important structural difference. Here's a second one. In the US context, neither the US Constitution nor any federal statute speaks to the issue of dissent. They're silent. And so whatever happens is entirely a function of judicial choice. In contrast, as we've seen, many, perhaps all, of the statutes creating courts speak to dissent, sometimes even if it's only by silence, or they have a permissive approach. There are also court rules. So in some ways, judges are a little bit more constrained because there are other decision makers. And so if you talk to ECJ judges, they'll tell you the decision whether dissent or not is not up to us. The statute told us that we don't have authority. I think that's a slightly tendentious reading of the statute, but that's for another day. So those are two important structural reasons, theoretically, why we might expect different practices. And then on the second, what in fact has happened pragmatically, and here I'll just mention two things. So one thing that is very interesting about the United States Supreme Court, if you think of it now, you would think of it as a very high dissent court. Actually, for much of its history, it was a low dissent court. So from the founding to 1941, it was a low dissent court. And then starting in 1941, it became a high dissent court. So its practices change dramatically. In contrast, at virtually all of the international courts, but for the African Human Rights Court, in virtually all the international courts, dissent practices have been consistent. At the ICJ, has been high since the day it opened its door. ITLOS, high across time, shorter time period. WTO, low across time. And so there's a stickiness. And one of the European judges we interviewed said, it is as if the Strasbourg and Luxembourg judges, when their courts opened, they got on different trains, on different tracks, and they just kept going, right? So there's something sticky And this is another, I think, research puzzle. Some judicial practices change dramatically, right? How do courts handle oral argument? In some courts, that's changed dramatically. How do they? There's lots of judicial practices that have changed. Somehow dissent practices have remained sticky. For us, that's an unexplained puzzle why that would be.
Thank you for that answer. Now, another question that we would like to ask is on the impact of dissent in, let's say, codifying the customary international law by International Law Commission or other bodies. Of course, as you have mentioned, that there is perhaps no case where the majority judgment is citing one of the prior judgments of the ICJ, one of the dissenting prior judgments of the ICJ. But what about the impact on the codification of international law? Any thought on that?
Yeah, what a great question. So, one kind of strand of that question is, what is the afterlife of dissents, right? Like, where do they, if anywhere, right? Where are they? And so it ends up that although they tend not to be cited in a subsequent, opinion of the court or judgment of the court, they do tend to get cited in subsequent separate opinions, even concurrences, separate dissents, separate declarations. I love the question because we have not, so the question is a partial answer to the earlier question, what would a future research agenda look like? We haven't yet, but this would be a really important step, look at the afterlife of dissents outside of judicial fora. So the ILC is a fantastic example. Legal scholarship. Are there other domains? Diplomatic practice, state practice. Are there other domains where these dissents have an afterlife? So just to give an example here, it is said that Judge Hirsch Lauterpacht's very powerful critique, in some separate opinions, very powerful critique of Connolly calls reservations, certain reservations, to the acceptance of ICJ jurisdiction, very trenchant criticisms, in part led to a reduction in the use of those sorts of reservations in state practice. So this wasn't directly like a doctrine, it didn't change legal, but it changed, arguably, had some influence perhaps in changing state practice. So it's a wonderful question. We haven't looked at the ILC in particular, but one could and should do that. That would be super interesting. But one could even expand it and look at other domains of international legal practice. So thank you. I love that question.
Thank you very much. So we are almost out of time. This would be our last question. Do you notice any particular difference depending on which area of the law the judges are dealing with, let's say human rights or international economic law, law of the sea, or this is more or less the same across the board?
Yeah, that's a great question. So I've not done a systematic study. Here's an anecdotal response for what it's worth. And maybe one of the talented students can do the systematic study and disprove this. But the anecdotal reaction is my senses and Law of the Sea Tribunal, many of the dissents, are on procedural questions, sort of fairness grounds, less so on substantive issues. Why much higher dissent rates in the human rights domain than the international economic area? There's a hypothesis out there that international economic law is sort of clearer, right? Less vague, less abstract, right? If the duty on trucks, is bound at 10%, and the duty on cars is bound at 5%, if a truck comes in at a 12% tariff, like that seems pretty clear in a way that maybe a more vague or abstract human rights stand. Like this is sort of the conventional wisdom. I confess that I don't find that particularly persuasive in the sense that much of human rights law is worried about discrimination of one type or another. Much of international trade law is worried about discrimination of one form or another. I think that's an equally vague concept in both domains. The other thing is, even where trade law seems to be clear, like cars have a duty of 5% and trucks have a duty of 10%, the question is going to be, well, what duty should a minivan have to pay? that's not so clear. So the conventional wisdom is trade law is more clear and more precise. I'll dissent from the conventional wisdom on that one.
Thank you very much for that answer. And of course, thank you very much for your talk and the time that you have spent for us. Thank you all, dear audience. So have a good day.
Thank you so much for the opportunity, and thanks for these questions. I've really enjoyed the conversation.
Thank you very much.
Okay, take care. Bye-bye.